Another legal setback for former President Donald Trump. He and three of his adult children face a multi-million-dollar lawsuit by the New York State Attorney General. They're accused of what was described yesterday as persistent fraudulent business schemes. So what exactly does that mean, and what's the legal jeopardy here? We're joined this afternoon by lawyer Seth Berenzweig, who's someone we turn to in these situations for some clarity. He is, of course, with the Berenzweig Leonard law firm. And Seth, great to have you with us. Thanks for your time. Letitia James yesterday made a pretty big and comprehensive presentation for reporters about the case that she and her office has made against the former president. What's your overall feeling? How much there is there in this?
Well, I think there's a lot of meat on the bone. This is a very serious and substantiated case. This 220-page complaint is the most direct and immediate threat to the Trump business and brand that has ever existed. And in this lawsuit, as you've noted, there are allegations of persistent and years worth of business fraud committed not only by Mr. Trump and the Trump organization, but since the Trump organization has been a relatively small business led by his children, the children are also involved in this case. So this is a lawsuit that is really one of the most direct threats that the former president has faced. And among the requests for relief that are asserted in the lawsuit is not only a demand for $250 million, but a termination of the business license, which is basically the business version of the death penalty, as well as an immediate conservatorship oversight of the business and eradicating any of their ability to conduct any business in New York. So this is a very serious and immediate threat.
This is a civil complaint as opposed to a criminal complaint. And that's important for a number of reasons, not the least of which is sort of the legal threshold here. It's not beyond a shadow of a doubt. It's 50% and a hair more than that you have to convince a jury, right?
You're absolutely right. Although these are very serious allegations that essentially wrap into what ultimately amount to criminal violations. The interesting feature that you've noted is that this is a civil enforcement case by the New York Attorney General's office. As a result, the case is strong, but the evidentiary burden of proof is really just merely a preponderance of the evidence, which is basically 51% or more. And if you want to have a little bit of a preview of how strong the case is likely going to be, I would refer you to the pre-trial or the pre-filing depositions of Eric Trump and Mr. Trump. And combined, they both asserted their Fifth Amendment right against self-incrimination over 600 times. So this is a very serious case, but it ties in with a civil burden of proof, and which is one of the reasons why it's so lethal.
And taking the fifth, again, in a civil complaint is different than if you do it in a criminal complaint, because in a criminal complaint, that can't be used against you. It can, however, be used against you in this civil proceeding.
That's exactly right. And not only can it be used against you in the civil proceeding, but then you would be entitled to what's known as an adverse inference. In other words, it is kind of a turbocharged direction to the jury to say that in the event that the party refuses to answer based upon their Fifth Amendment right against self-incrimination, the jury is instructed that it must presume the negative answer to the question being presented to the witness. If you multiply that by the hundreds of times that was asserted in the pre-filing deposition, you can see how grave and serious of a threat this is. And the thing that made yesterday so fascinating was that the day was punctuated by the 11th Circuit's announcement in the document retrieval case, not to get lost in the legal weeds here, but a very serious and related loss for the former president, where there was an overturning of the district court ruling. So not only yesterday was the former president faced with a very lethal civil lawsuit, but there was an order releasing the Justice Department's ability to use the classified documents in its investigative materials regarding a potential criminal proceeding.
You anticipated my follow-up question to you, Seth, about the 11th Circuit.
Yep.
And those appellate judges had some pretty strong words for the judge who issued this original ruling that denied the Justice Department the availability to these documents. They said it was less than a flimsy case. There was almost no case to be made here.
Think about how unusual this development was yesterday. It was unusual in a couple of different respects. When you're talking about federal appellate litigation, these are cases that usually move, those wheels of justice typically grind slowly.
Yes.
There's briefings and there's arguments. No, in this instance, not only did you have, as you have correctly noted, a very scathing ruling by the justices yesterday, most of whom were Trump appointees, but it happened within a matter of days. That is very rare. And the reason it happened that way is because we're talking about documents with national security implications. So from a legal perspective, we really are witnessing history right before our eyes.
Seth Berenzweig with the Berenzweig Leonard law firm. And he always is very good at this, of making digestible bits out of what are sometimes pretty obscure and sometimes very complicated legal movements here. Seth, many thanks. Good to see you again.
You bet.